This video was created with AI to support SQE1 study. We are independent and have no affiliation with the SRA, Kaplan, or the SQE. We do not share exam content, and our videos are for informational purposes only and should not be used as legal advice. Please check and refer to primary legal sources and recommended prep guides as you study.
Hello and welcome. If you're tackling the SQE1, you know tort law is a huge part of it. And one of the trickiest but most essential topics you've got to nail is vicarious liability. So in this explainer, we're going to break it down, make it simple, and get you totally exam ready. So let's just paint a picture. Imagine an employee makes a really bad mistake, a big one, and someone gets hurt. The victim quite rightly wants compensation. But what if the employee has no money? I mean, what then? Is that just tough luck for the victim? Well, this is the exact scenario that the whole doctrine of vicarious liability is designed to deal with. So what is it technically? It's a type of strict no-fault liability. Now, that phrase no fault is absolutely crucial. It doesn't mean the employer did anything wrong themselves. Not at all. It means the law steps in and holds them responsible for the wrongful act, the tort, committed by their employee. Okay, to really get this, we're going to follow a really clear roadmap. First, we'll ask why this rule even exists. Then we'll get into the nitty-gritty of the modern two-stage legal test. This is your absolute must-know for the exam. After that, you'll get to put it all into practice with some questions before we finish up with a super handy revision checklist. So let's start with the big question. Why? Why do we have a rule that seems to blame someone who wasn't actually at fault? It feels a bit strange, right? Well, the reasons behind it are all about fairness, justice, and public policy. And you know, this isn't some newfangled idea. This quote shows that way back in the year 1700, the courts were already grappling with this. The core idea is simple. If someone has to lose out, it's more fair that it's the person who created the risk and stood to profit from the employee's work, the employer, rather than an innocent stranger. It's about who has the deep pockets to actually compensate the victim. Okay, for any problem question you get on the SQE1, this is the framework you must use. It's a two-stage test. First, you have to prove there's the right kind of relationship. And second, you have to show that the bad act was closely connected to that relationship. So let's break down each of those stages one by one. Stage 1. This is all about what kind of relationship we're looking at. The big fundamental question here is this: was the person who committed the tort an employee, or were they an independent contractor, someone basically running their own business? This distinction is everything. So, how do the courts decide? They look at the reality of the arrangement. You'll hear this bit of legal jargon: a contract of service versus a contract for services. The easy way to remember this is that an employee is part of the business. They're integrated. An independent contractor provides services for the business. They have their own autonomy and they bear their own commercial risk. Now, the absolute key case you need for stage 1 is this one: Barclays Bank from 2020. It's a Supreme Court decision, and it's so important because it really clarified the boundaries, especially when we're talking about people who aren't your typical 9-to-5 employees. So in this case, a doctor was hired by Barclays as a contractor, and he committed horrific sexual assaults. The victims argued that his relationship with the bank was so close it was akin to employment, but the Supreme Court said no. They made it crystal clear: if someone is genuinely running their own business, like this doctor was, then the principle of vicarious liability just doesn't apply. Okay, so let's apply that to an exam-style scenario. A law firm brings in a freelance IT consultant who totally messes up and deletes a crucial client file. Is the firm on the hook? Well, applying that Barclays principle, the answer is almost certainly no. The consultant is an independent contractor, so the firm is not vicariously liable for their negligence. All right, once you've ticked the box for stage 1, you've established the right relationship. Now we move to stage 2, the connection. And I'll tell you what, this is where most of the legal battles are fought. Just because someone is an employee, it doesn't automatically mean the employer is liable. You still have to prove their wrongful act happened in the course of employment. And the test for this has really evolved over time. It started out pretty simple with something called the Salmon test. Basically, was the employee just doing their job but in an unauthorized way? But then you had these really difficult cases involving intentional wrongs, like assaults, and that old test just didn't work. This led to the modern close connection test, which has been tweaked and refined in a whole series of really important cases. And here it is, this quote from the massive case of Lister gives us the modern test. The question isn't just about what the employee was doing. It's whether the act was so closely connected with their job that it would be fair and just to make the employer pay. That's the exact phrasing you need to have in your head for the exam. This slide illustrates the difference perfectly with two classic cases. In Limpus, you have a bus driver. His job is to drive. He was told not to race other buses, but he did it anyway. He was doing his authorized job just in a prohibited way. So the employer was liable. Now contrast that with Beard. Here, a bus conductor, whose job is to collect fares, not drive, decides to take the wheel and crashes. That's a totally unauthorized act. It was never his job to begin with, so the employer was not liable. Now for these two huge cases, both involving Morrisons. It's like a tale of two torts. In the first one, Mohamud, a petrol station attendant, assaults a customer. The court found that this was all part of a seamless episode that was connected to his job of serving customers. So Morrisons was held liable. But fast forward to 2020. This time, a disgruntled employee leaks company data out of a personal grudge. The court said no, this was a personal vendetta. He was on a frolic of his own. This wasn't connected to his duties. So Morrisons was not liable. What this shows is that the employee's motive can be a really key factor. So how does this actually apply in a problem question? Okay, scenario 1. A bouncer argues with someone about getting into a club, follows them outside, and assaults them. Is the club liable? Yeah, that's looking very likely, following the reasoning in Muhammad. Scenario 2. A bitter accountant leaks company secrets to get revenge on his boss. Is the company on the hook? Probably not. That looks a lot more like a personal act of vengeance, breaking the connection, just like we saw in that second Morrisons case. Okay, you've got the theory, you've seen the cases. Now let's see how you do under a bit of exam pressure. We're going to try a couple of SQE-style questions. All right, first one up, you've got a delivery driver on her route who gets into a road rage incident and assaults another driver. And the company has a strict no-violence policy. So, is the company liable? Have a good look at the options. Which one is the best answer? And the correct answer is D. Why? Well, remember the bus driver in Limpus? Just because the company prohibits something, that doesn't get them off the hook. If the argument started because of something to do with her job, like her driving the company van, then the assault can be seen as closely connected to her work. It's just a very, very improper way of doing her job. Okay, question 2. A shelf stacker at a supermarket gets on a work computer, steals a load of employee data, and sells it. Is the supermarket liable? Really think about the connection between his job, stacking shelves, and what he actually did. And the answer here is C. And this is such an important point. His job, stocking shelves, merely gave him the opportunity to commit the tort. But opportunity is not the same as connection. His authorized duties had absolutely nothing to do with handling data. There's no close connection here, so the employer is not liable. Excellent work. Right. Let's wrap this all up and distill it down into a final high-impact checklist for your revision notes. This is the stuff you absolutely have to remember. Okay, so here are your key takeaways. 1. Always, always use the two-stage test. For stage 1, it's all about Barclays and that independent contractor rule. For stage 2, remember the close connection test from Lister, and then think about the nuances from cases like Limpus and the two Morrisons decisions. Now, be really careful about the common exam traps. Don't confuse mere opportunity with a close connection. And don't ever think that just because an employer has a rule against something, that's an automatic defense. It isn't. And one final vital point to leave you with: vicarious liability doesn't mean the employee gets away scot-free. They are still personally liable for the tort they committed. The employer could even, in theory, sue them to get the money back. Now, that's a detail that could really make your answer stand out.